Good morning and welcome to the Shankman Wealth Management Accountant Attorney Spring Webinar Series. This program is entitled Coming to America, Immigration, Tax, and Estate Planning Considerations. For those who don't know me, my name is Jonathan Shankman. I'm the president of Shankman Wealth Management. In that role, I work as a financial advisor, portfolio manager, and serve in a fiduciary capacity to help my clients achieve their financial objectives. The goal of my programs is to bring professionals together to help them better serve their clients. This is done by educating attendees on the latest topics in wealth planning and by encouraging collaboration between a client's attorney, CPA, and financial advisor where appropriate. My practice focuses on working with high net worth families, businesses, and not-for-profits. I manage individual investment portfolios, trust accounts, corporate retirement plans, and endowments to help my clients achieve their financial goals. In addition to the 25 or so events I run every year, I also do a fair amount of writing on the topics of investing and financial planning. You could read my work in Barron's, Bloomberg, CNBC, Fortune, Forbes, Kiplinger, the Wall Street Journal, the CPA Journal, Trust and Estates Magazine, and many other periodicals. You can see all my work on my website at shankmanwealth.com/articles or follow me on social media at Shankman on Money. Additionally, I just launched my podcast, which is also called Shankman on Money, and you can check that out at Apple Podcasts, Spotify, or wherever you get your podcasts. One more quick note before I introduce our esteemed panelists, and that is about the CPE and CLE credit for this program. If you are a Connecticut, New York, or New Jersey-based attorney or CPA, please pay close attention. I'll be giving a code during this program that you must write down, so please have a pen and paper ready. After the program, you'll receive an evaluation form where you will need to insert the code in order to receive credit. Now, with that introduction out of the way, I'd like to give a short bio for each of our three esteemed panelists. First, Michael Wilds is a managing partner with the leading immigration law firm Wilds & Weinberg, located in New York City, Miami, and New Jersey. He serves as counsel to Lincoln Center and several international corporate law firms. A former federal prosecutor with the United States Attorney's Office in Brooklyn, he has testified on Capitol Hill in connection with anti-terrorism legislation and is internationally renowned for his successful representation of distinguished individuals, including former First Lady Melania Trump and soccer legend star Pele. Larry Lipoff is director in CohnReznick's Trust and Estate Practice, based in the firm's New York office, with more than 30 years of experience specializing in the delivery of domestic and international private client services to enable high net worth individuals and families maximize their new or generational wealth. And finally, Eli Akhavan is a partner at Steptoe & Johnson, where he focuses on tax and estate planning for high net worth U.S. and non-U.S. clients. He advises domestic and international individuals and families with respect to tax and estate planning for their U.S. assets and beneficiaries. Eli also advises cross-border clients on all aspects of international estate matters, including foreign trust, pre-immigration and expatriation planning, and on planning for the purchase of U.S. residential and investment real property. Today, Michael, Larry, and Eli will be discussing Coming to America, pre-immigration tax and estate planning considerations. Now, before we launch into the meat of our program, I'd like to ask each speaker to spend just 30 seconds to tell us a bit more about their practice area in case I left anything out. So let's first go to Michael.
Thank you so much for hosting me, and I'm honored to be with these other distinguished panelists. The law firm Wilds & Weinberg that I manage was started by my father. He should live to 120. He's actually 90 years young. He started it in the same building where we're paying rent on 53rd and Madison in Midtown. All we do is U.S. immigration, New York, New Jersey, Miami, and by appointment only in Los Angeles and Tel Aviv. We have 5 divisions. We deal with business visas. I teach business immigration law at Cardozo Law School. We have a family unit. We litigate in federal court and in immigration court, trying to move our clients' matters forward if we need to. We have a robust consular practice and ultimately a onboarding and compliance, I-9s and all of that. We're generally the first lawyer that a foreign national meets, and before they even make a decision to take a green card, a visa, or citizenship, or to give it up for tax reasons, we're often the first lawyer, and we make a lot of referrals. So I'd love to hear from you if I could be of any support.
Great. And let's turn to Larry for just a 30-second overview.
Thank you very much. So, Jonathan mentioned that I'm at CohnReznick, part of the National Tax Department. One of the things is going on that I find pretty interesting is that as I get more years of experience, that seeing these specialization in accounting and legal practice as well, that it's good to be a generalist. So I was a tax generalist before I became a specialist, first in S corporations and then domestic and then international trust and estate work. And I find that being able to jump through and see things from a holistic viewpoint is very helpful as being part of a professional team, and especially for our mutual clients. And hopefully some of those issues will come to play in today's session, but also as matters come up going forward, if it could be helpful, very helpful, happy to do that. And having such a fantastic team of professionals, I appreciate being added to the program.
Great, thank you. And let's turn to Eli for a quick overview of his practice.
Good morning, everybody. Thank you for joining in today. Thank you to Jonathan for arranging all this and this terrific panel. I'm happy to be on with Larry and Michael. As Jonathan mentioned, I'm a partner in Steptoe & Johnson's Tax and Private Client Group practice. I focus on domestic and international estate planning. I'm involved in various both domestic as well as international bar associations that deal with cross-border issues. I've taught international taxation at St. John's University School of Law. This year in particular, I've had a lot of opportunity to travel abroad. And the trend that we're seeing is that people from abroad view the US as a safe haven. And even if they're not prepared to move themselves yet, they're certainly moving their assets. If they have adult children, they're encouraging them to move to the US. So you're going to find today's program quite informative to at least have the high level overview of the issues that you should advise your clients on.
Great, thank you so much, Eli. Now let's turn back to Michael, just to set the stage for us to first discuss the immigration planning process. My first question is basic, but of interest to many, and that is, how long does the immigration process typically take?
Well, thank you. And first, I didn't plug, when Eli said safe haven, I actually wrote a book and it's called Safe Haven in America. So it's available if I don't put you to sleep. How long does the process take, Jonathan? As long as you let it. We're experts in our office at speeding things up when they're going too slow and choosing options from the outset where timing becomes the most relevant feature. Many lawyers convince clients to apply for green cards right away, but that's often the wrong strategy and strips a client of control over the process. My dad trained me to give somebody a visa solution, but place them in a position where one day they may want to apply for a green card or retreat back. Put them in a visa that allows for a dual intent, but don't necessarily go there without taking good tax counsel. To do the green card process properly through an embassy, it can easily, on timing, Jonathan, take about 2 years. Well, often we want to find a temporary solution to give a person the ability to enter, to start working, and then handle the green card on their timeline to limit the inconvenience. We've done cases with clients in the United States who later go get their green cards abroad. We've done domestic clients where clients travel from before we start until the case ends. And for clients with limited needs, the key is planning ahead to make sure that they have the right visa to start and the timing is lined up. When things go sideways and people come to us to complain that their case is taking forever with another lawyer, we then look for intermittent solutions, whether that's an H-1B, a professional work visa, the acronym HELLO, H-E-L-O, the H visa, the one that's a specialty occupation if you have a degree, gives you a proper installation. Investors, entrepreneurs, risk takers, those E-visas that have make America our founding documents and founding parents proud a generation later, or the intercompany transfer, the L visa, or for the rock stars, those O visas, people who are distinguished in their space. Sometimes we have to go not just for those lettered visa band-aids, but also emergency advance parole, travel permission, or mandamus lawsuits, go to federal court to bully the government into moving our clients to the front of the line.
A comment I've heard from clients is, I want to move to America, but my accountant told me to avoid a green card. You may have touched on this a bit, But for an individual like this, what are their options?
A lot of our clients come in and you can tell that they're allergic to a green card for tax purposes, and they're under different impressions what a green card, what citizenship. And there are a lot of people that have exposure or they're multinationals of several countries. You have to make sure that you see things in the room that your client may not anticipate. It's a common situation for our clients, and there are a few key factors to consider, including current employment, their credentials, and planned activities in the United States. Is there a brief, innocent, and casual need to be in America? Is there a relative that they're seeing, and so forth? If a person will be running their own business, we generally want to do a top-down assessment to include the eligibility for those L1s, the E1s, the Os, those international entrepreneurs, visas, and other options. The L and the E are the nice visas because they give a long term on each visa. I've had oil magnates that have been in America on E2s for 30 years. We've had clients that they watch days so that they run a sconce of taxation and visas at the same time. The L and the E2 are nice because they give a longer term for each visa, meaning less trips to the embassy. There are reciprocal relationships that we have with particular countries, so it's nuanced by where the person is from. But the L1 is not a status that can be held indefinitely, and it requires the company to have operations, employees in both the United States and abroad, and that can potentially create business expense that's unnecessary. I like those visas, but I love the O visa because it's great for people who want to dabble in multiple businesses, working for different jobs. They can be their own gentleman, gentle lady if they want. It gives them flexibility to potentially renew indefinitely, but you have to have risen to a level of achievement in your space. One half measure that sometimes works for people who want to buy time in applying for a green card with USCIS, which is immigration, but not finishing the process as a Band-Aid, is sometimes a way to have a cake and eat it too. You can also have couples, particularly where one party gets a green card and it includes children up to the age of 21, and then the principal person with wealth doesn't. We have a billionaire Canadian family with the entire family, literally about 30 people on E2 visas, dozens of people living full-time in the United States, minimizing the tax burden and doing everything properly according to immigration law, because there are many loopholes or nuances that we know how to work. We've also gotten other creative solutions where we use for clients, but a few key questions are usually enough to help point us in the right direction, and we have that capability of doing it in the initial intake.
Many of the attendees on this webinar are advisors to high net worth families living abroad, some of which are eager to move and work in the US. Can you tell us a bit about the EB-5 program, how it works, and any best practices for advisors to consider when speaking to their clients?
No problem. My father actually testified on Capitol Hill in support of the EB-5 program, and it is robust. We have, thank God, a stellar record in dealing with those cases. The EB-5 program is essentially a government-approved way of buying a green card. Technically speaking, it's an investment in the United States project, which means that the money can earn a return and be recouped at the end of the project. Investments amounts, there are three kinds of EB-5s. One, you put $1,050,000 into a business where you're paying 10 people to do work. That may be hard in this economy to sustain. The second one is if you're doing $800,000 in a rural area where unemployment is very high. Or third is a regional center, a matrix of about 875 companies that have been pre-approved, where you give them 800K and you get it back 6 years later. EB-5 investments tend to have a lower return and higher risk than other investments. Oftentimes, other investors are EB-5 investors, as most people just look for a return, seem to steer clear. And there are many anecdotes of investment schemes run by shady operators. If you Google it, you'll see it's very disturbing, and there are a lot of unethical practices historically in this space. There's a double whammy, because if the funds are stolen or the project doesn't go as planned, it could also mean that the investor doesn't qualify for the visa. You get a conditional green card only good for 2 years. You then have to file a petition to remove the conditions to the green card, much like in marriage cases, the government wants a look back. Knock on wood, to date, our EB-5 clients have not lost money and all have received their money back, going with reputable investment opportunities and professionals like you. I'm not licensed to tell them where to put their money, is substantial and critical to achieving a good outcome. The process to obtain the conditional green card is lengthy. It often takes 3 years. And for that reason, we have to look for another visa solution or put the party abroad. We have a lot of Russian and Chinese magnets where the principal doesn't go for tax reasons, but the spouse goes with the children up to the age of 21. Again, once successful, immigrants get a conditional 2-year green card. 90 days before the end of the 2-year period, you file another petition to remove the conditions, thus making them a full permanent resident. So you have to make sure you stay with a law firm that knows what they're doing. In every case, the EB-5 investors must be able to demonstrate a lawful source and a path of funds. These applications are, feet long, not inches long in our office. And often we do a deep dive for our client to make sure that it's sourced out properly and that they understand. The law lapsed last year, which is a ridiculous experience, where there were 50,000 people who had invested these substantial funds and their case was lost in the shuffle, which is a remarkable experience. So you have to be able to warn your clients and pivot if there are delays from COVID to even happenstance in Congress, who is a mess when it comes to these things, unfortunately.
Great. Thank you, Michael, for that helpful background and setting the stage for us.